convinced to hear the appeal in public prosecutor against the accused. Counsel proceed.
Your Honor, the prosecution will show a chain of recurring bribe payment, a massive unexplained cash transaction, a proper statutory inference under Anti-Money Laundering, Anti-Terrorism Financing and Proceed of Unlawful Activities Act 2001, also known as AMIRUL Section 4, Subsection 2. And lastly, the correct standard of proof under Section 56, Clause 4 and Section 70.
Your Honor, the defense will now address the credibility of each witnesses presented, the inconsistencies in timing, and also the insufficiency of evidence to meet the standard criminal of.
Your Honor, this is what actually happened. Since 2009, every month, I delivered 3,000 ringgit to the accused. Always the same amount, always the same purpose, to keep my gambling business running free from police raids.
This is a consistent pattern throughout the year. It's formed on the foundation of unlawful activities.
Your Honor, while the narrative is dramatic, the defense notes that the payment alone does not prove that the accused had received, knew, or used the money. We challenge the chain of custody from the letterbox to the accused.
This payment were part of a scheme, and charge 1 and 2 and 3 and 4 was fall on the same days, forming a one same transaction.
Your Honor, sometimes I didn't do it myself. My workers delivered the 300,000 envelopes. The goal was to keep enforcement of our bags. He was in vice and gambling prevention, so he had power.
Your Honor, the defense raises an important point. The workers who delivered the envelopes were never called to the court. This may invoke Section 114, Subsection G of the Evidence Act 1950 that talks about adverse inference.
Alright, the Court of Appeal held otherwise, where the prosecution evidence is coherent. The non-calling of additional witness does not create an adverse inference.
Correct. The prosecution's testimony stands.
Your Honor, he paid cash, huge amounts, RM40,000, RM500,000 and RM993,716. All were used to purchase takaful products registered to him or his child.
This directly supports charge 1 to 7, which is use of illegal proceeds.
Your Honor, agents do not verify the legality of cash. Without proving the origin of the money, the prosecution leans heavily on making an inference under Section 4, Subsection 2 of the AMIRUL. The defense submits that mere inference cannot substitute an evidence.
Let the record clarify. Firstly, Section 56, Subsection 4 of AMIRUL. To determine whether a property is considered proceeds of unlawful activity, the court uses the civil standard, which is balance of probabilities. Secondly, Section 17, Subsection 2 of AMIRUL. However, to convict under Section 4, Subsection 1, the court uses the criminal standard beyond the reasonable doubt. Thirdly, Section 4, Subsection 2 of AMIRUL, where a person handles suspicious funds and fails to verify their legitimacy, the court may infer.
Your Honor, we, the defense, acknowledge these principles. However, our position still remains that the prosecution's factual basis does not justify the inference or meet the criminal standard of proof.
And we submit the opposite.
Your Honor, I deny receiving any money. I deny knowing anything about the letterbox. I deny using illegal money. The funds were from loans. That is my answer.
Sir, is there any evidence to support the 3 million ringgit loan that was made even before the charges were claimed?
No, but I deny everything.
This court delivered its analysis. First, on the same transaction, charges occurring on identical dates on 4 September 2014 and 60 December 2014. They form single transaction due to clear proximity. This was correctly applied. Secondly, on proceeds of unlawful activity under section 56 subsection 4. Assessing on balance of probabilities, the recurring bribe payments, the takaful cash injections, and 1.27 million ringgit and 8.17 million rupiah seized show the funds were proceeds of unlawful activity. Thirdly, on money laundering offence under section 4 subsection 1, applying beyond reasonable doubt under section 17 subsection 2, the prosecution successfully established the evidence of usage of substantial cash, pattern consistent with illegal bribery, implausible defense loan explanation, and absence of any legitimate financial source. Fourth, on statutory inference. Under section 4, subsection 2, the accused failure to verify, explain, or justify possession of massive cash activities, inference of knowledge. And lastly, on the defense position, pure denial is not evidence and does not discharge the burden once inference arises. Thus, given the totality of evidence, this court affirms the conviction.
Inference corroborated with consistent facts makes a one compelling proof of evidence, and this also reinforces the principles that a defense must be substantive. It cannot be relied purely on bare denial. Paper trails always speak.
We shouldn't get involved. I could have done differently. I shouldn't have done. Tiba-tiba lost. I should.
Is court convinced to her
This is a
Sufficiency of evidence to meet the standard criminal of. Apa boleh tu?
Abdul.
Sebut.
Like it.
RM500,000 and 900. 900 pula RM5. Aku dah kau. RM9,983.